Hi, Phil Brunner here. I think we're live at the moment. For today's session, Facebook Live session. So, Phil Brunner, Bailiwick Legal. Do I need to go through that spiel again each and every time? Well, maybe yes. So, Bailiwick Legal, we specialise in agriculture and tourism, and we cover all aspects of those industries. We don't do criminal and family law, just so you are aware. But otherwise, all aspects: employment, property, estate planning, business succession, and the like. Yep. So that's a very brief snapshot about us. Okay, today's topic is what people refer to as fit for purpose. The concept of fit for purpose and what that means in a very generic sense, and how, particularly with agricultural clients and people farming, how they can deal with usually machinery that they've purchased, which, using the term, is not fit for purpose. Perhaps a little background to this. Through my involvement with farming over the last 21 years, my God, it's been a long time, hasn't it? It's been enjoyable nonetheless, must say. It's been entertaining, enjoyable, and I've met a bunch of very, very interesting and likeable people. Digress. Over that 21-year period of time, I don't have enough hands and feet really to count the number of times we've had contact from farmers who have purchased machinery, typically machinery, which has not performed to the expectations that they've required of that piece of machinery. This sort of also goes to maintenance of machinery as well. Again, I don't have enough hands and feet to count the number of calls we've had and queries we've had from farmer clients and others in relation to repairs and maintenance costs and failures. But for today's purpose, we're really going to concentrate on the generic concept of fit for purpose and what that actually means. The best place to start really is looking at the Australian consumer law, and that's Commonwealth law, applies across all states. Under Section 54 of the Australian consumer law, the concept of fit for purpose will be a reference to goods which must be of acceptable quality that are, firstly, fit for all the purposes for which goods of that kind are commonly supplied; secondly, acceptable in appearance and finish; third, free from defects; fourth, safe; and lastly, durable. Those requirements are not absolute, but are subject to what a reasonable consumer would regard as acceptable, where that consumer is fully acquainted with the state and condition of the product, including any hidden defects. So it falls back to a reasonable bystander type of test when a court is considering those aspects. Right, so you've purchased a piece of machinery, let's say it's a sprayer, and it is not doing its job. Well, what are your causes of action? What can you do about that? The usual causes of action that flow from that situation is breach of the Australian consumer law, so it's a statutory breach. All right, and that's usually falls within two categories. It's either misleading and deceptive conduct through misleading and deceptive representations. Best way of explaining that is, prior to your purchase, you've gone to a dealer, you've picked up a pamphlet, or you may have even been at the Darren Field Day and picked up a pamphlet. You've had a discussion with a representative. You've then gone to the dealership, had further discussions, and based upon those discussions and the representations in the pamphlets and any other documents they've given you, sometimes they even direct you to websites so you can actually have a look at the product online in situ and moving. So all those things combined are representations about this particular sprayer. If once you've got the sprayer it just does not work, well, it's not fit for purpose. It must work, right? If it doesn't work, it's not free from defects, it's not durable, it's not fit for the purpose of spraying that you purchased it for. So pretty straightforward concept when you actually start thinking about it. So as I said, typically under the Australian consumer law, the misleading and deceptive conduct cause of action is a go-to remedy. So are, under the same consumer law, consumer guarantees. Under the consumer law, there are various consumer guarantees that are statute-based, that companies cannot contract out of. So let's say for a manufacturer and importer of goods, the statutory guarantees are that the goods are of acceptable quality, that they have been accurately described, that they satisfy the manufacturer's express warranty, and they have spare parts and repair facilities available for a reasonable period of time. For a business that sells the goods, so when you talk about a sprayer, you've got a retailer, there's various agricultural machinery merchants throughout Western Australia that sell goods to you. Now, often they're not the manufacturers of those goods, but they are selling those goods to you. So as part of that sale obligation, these consumer guarantees go with it. And those guarantees are also sort of flip into the fit for purpose brackets. So acceptable quality, the goods must be safe, lasting, have no faults, look acceptable, and do the things that you would expect them to do, i.e. for a boom sprayer, it's got to spray. And if you have identified in your discussions with the reps and the dealership, if you've identified specific needs for your particular farm, then if the machine does not meet those specific needs that you've identified, then again, it's not fit for the purpose you've required. So there's a number of other guarantees that apply to the seller of goods as well, that sort of expand upon the concept of fit for purpose. So we flip back then, you've got those two concepts of misleading and deceptive conduct and consumer guarantees under the Australian consumer law. The other typical cause of action is a breach of contract, right? Simple breach of contract. And there may be provisions, express provisions in the contract which provide warranties about the machine being fit for purpose and the like. So there may be some express terms. Usually though, there is no express term to that effect, understandably. manufacturers, sellers of goods usually try and limit their liability to these types of things all over the shop, and you'd be familiar with how they do that. But fortuitously, under the sale of goods legislation, so in WA we have a Sale of Goods Act, which deals with many things, including this concept of fit for purpose and merchantable quality. So under section 14 of the Sale of Goods Act, an implied term in every contract of sale for machinery is a term that the machine be fit for purpose. Also under that section is a statutory implied term to the effect that the machine would be of merchantable quality. So those things are implied into the contract of sale of that machine. And so often you will have a case where you've got a breach of contract, cause of action against the dealership, I'll say, because it typically is a dealership. It could be another farmer who sold this to you, but typically it's a dealership. And so you have a breach of the contract, a claim against the dealership, and you may also have a breach of the Australian consumer law claim against the same dealership, because they've been displaying the pamphlets, they've been directing you to relevant information pertaining to what this machine, this sprayer is meant to do. And so you've got two claims generally, statutory based and contractual, against the seller of the machine. You may also have claims against the manufacturer and or importer of the machine if that entity has also made representations about the merchantability and quality and purpose of the machine. All right, so that's a really very brief synopsis of the claims itself. I'm not going to go into the sort of detail of what those claims look like. That's not really today's purpose. Maybe we'll do that at some future point in time. Wait and see. By themselves, of course, breach of contract, we could do a whole different section on that one. Many types of breach of contract, and many types of repudiatory conduct that we covered there too. Misleading and deceptive conduct as a concept is also something big enough for a separate session on live Facebook too, but we'll think about those and maybe do them later if we have enough interest. All right, so they're typically your causes of action, and the misleading and deceptive conduct and consumer guarantees. I'll come to the consumer guarantees again a bit now, because there is a real catch with consumer guarantees. Whilst there are remedies under the consumer guarantees, statutory remedies, which include obligations to repair machinery, to replace machinery, to refund monies and return the product, they are remedies available under the consumer law for a breach of a guarantee, a consumer guarantee. But the real problem for farming businesses typically, with respect to consumer guarantees, is that where the product that you've purchased, where the value of that product you've purchased exceeds $100,000. Whoa, that was a big mistake, wasn't it? Where the value of that purchase exceeds $100,000, you cannot. Those remedies aren't available. The repair, replacement, refund, cancellation, and compensation don't come into play. So you may be in a situation, and typically this will be the case for most of the farm machinery out there, certainly in broadacre farming, your machines are typically going to cost you more than $100,000. So in those situations, whilst the consumer guarantees may well apply, the statute law doesn't give you the right to a remedy. If the product's under $100,000, go to town, right? You've got those guarantees, they're locked in, and you can seek a remedy pursuant to those the repair, replacement, refund concepts within the Australian consumer law provisions. Now, again, a bit of a catch on the consumer laws. That $100,000 benchmark was only effective from 1 July this year. Prior to that, the benchmark was $40,000. And I guess you can buy some farm machinery for less than $40,000. There'll be some things, chainsaw, maybe a tiny tractor under 40 grand. But it's not hard to realise that threshold is just insufficient from an agricultural farm machine perspective. Even $100,000 is really insufficient. I am aware, though, that I think it's the grain growers group has been lobbying to increase that threshold, and they did lobby to increase the threshold from $40,000 to $100,000 through recent engagement with the ACCC process. So $100,000 is certainly better than $40,000, but generally pretty much insufficient in today's environment for most large agricultural machineries used in broadacre farming. So where does that leave us? That leaves us a situation where, under the Australian consumer law, most often the claim is going to fall within the misleading, deceptive conduct realm. Right, where the machine does not work, is not fit for purpose, maybe works for one season then falls apart. Maybe does 300 hours when you expect 30,000 hours of it and then falls apart. Those types of situations. You really need to be looking at whether the machine is fit for purpose at the time of purchase and thereafter. Right, the concept of the machine being free from defects, safe and durable, those concepts fall within the general concept of fit for purpose. So where a machine fails within, say, 1 or 2 years of purchase, arguably it's not durable. Arguably it was never fit for purpose, and it had some inherent defect that has only come to light after being in operation for a short period of time. So, misleading and deceptive conduct and breach of contract are your typical prime causes of action on a claim for fit for purpose. All right, well, you've thrown them into your written statement of claim in court proceedings. You've gone to trial. You've succeeded at trial. The court's determined that the machine's not fit for purpose and there's been a breach of contract. So what? What's your remedy? Well, at that juncture, your remedy really is in this concept of damages. So on a few matters we're dealing with and have dealt with, the damages could certainly are the cost of the machine. All right, may well be also you could consider damages to be the differential between the cost of the machine and what you can actually sell it for right now. The damages might also extend to whether the machine's been financed and whether you've had to pay finance on a machine that's no bloody good. So there are extensions to the concept of damages. Typically, under the ACL, under the Australian Consumer Law, your breadth of remedy is generally typically larger than simply a breach of contract. A breach of contract, as a general concept for remedy, is putting you in the position you would have been in but for the breach. Well, that would be putting you back into a machine that actually worked. In my experience, that rarely ever is the result. Often in these circumstances there's an effort to repair and remedy a defect rather than take the machine back and supply a new one. And those repair remedy efforts, sometimes they'll work. In my experience, most often the repairs and remedies don't really appease the farmer and don't necessarily solve the inherent problem with the machine in the first place. Now, I'm generalising, may not always be the case, but that's been our experience to date. So when we talk about the remedy and damages as the remedy, the cost of getting a contractor in to do the contract spraying whilst your machine sits idle because it can't do what it was meant to do, that's again damages likely to be claimable. So the loss can be measured in many different ways. So I think that's a pretty quick synopsis actually of Fit for Purpose. I'm a bit surprised I've ripped through that so fast, to be honest. I thought it would take me a little longer to work through that picture. So really, as I said, I've lost count of how many times we've been approached with respect to this concept of fit for purpose. It shouldn't pervade agriculture. Unfortunately, my experience tells me it does. There's invariably each and every year machines that are sold that don't fulfill the job they're required to do, and typically farmers bear the brunt and the cost of that. In some senses, Australia is also, my personal view, a market seen as an experimental market for a lot of manufacturers and importers, an experimental market for machines to see whether they work or don't work and what will and won't work. And again, I don't really think that's appropriate. It's not ethical, and it leads to disputes around this concept of fit for purpose, unfortunately. So if you are in a situation where you've purchased a machine and it's really not performing as it should and as has been represented to you, or as you want it to after you've requested particular operational requirements, then please get on the blower. Let's discuss that and have a chat and see whether we can actually help you with that. Okay, I think that's all for me today, and I can't remember my normal sign-off. I've just been on holiday for a week. I'm back at the desk this week, and it's been a challenge to actually catch up on stuff. So Yep. Any other issues, just give us a call in the office here, 9321 and we'll see if we can help you. Otherwise, enjoy your day and keep safe. Thanks.